24P0934, the Department of Children and Families and Others versus Mother and Others. I remind everybody that this matter is impounded. So we will hear from you, Mom.
Thank you. I would just like to start by saying thank you for allowing me to appear virtually. It started off we were having a little trouble there, but now you guys can hear me clearly, right?
We can.
Okay. My name is Ruth. I come before you today to address profound and persistent systemic failures by the Department of Children and Families.
So I'm just
failures by...
I know you have something you want to read. I'm just going to remind you that this case are impounded. So try not to use any of the real names, okay?
Okay.
Okay.
As I come before you today to address profound and persistent systemic failures by the Department of Children and Families, failures violating its core statutory mandate under Massachusetts General Law, Chapter 119, contravening established legal principles and devastating my family across 2 generations. The issues before you are not only about the specific injustices in my case, but also present a critical opportunity to set precedent regarding the rights and treatment of parents and children with disabilities interacting with the foster care system in Massachusetts. The foundational policy of the Commonwealth, stated clearly in Mass General Law, Chapter 119, Section 1, is the strengthening encouragement of family life and providing services to ensure children can remain with or return to their parents. Yet my experience reveals a profound betrayal of this mandate. DCF's involvement exacerbated my struggles with codependency and housing instability, core issues they failed to meaningfully address despite their direct relevance to reunification. This ordeal reflects a devastating generational pattern originating within the very system mandated by Mass General Law, Chapter 119 to protect. This pattern began with DCF's catastrophic failure to protect my own mother while she was a minor in the foster care system. She was subjected to statutory rape by
Hello, I'm going to interrupt you just a little bit, okay? Because let's pick up in 2016, right? That was the time that you had the redetermination hearing, is that right?
That's correct.
Okay. So beginning in 2016, have you had stable housing?
I have.
And in what town have you resided since 2016?
I reside in Springfield, Massachusetts.
And you've been in the same location for the entire, 7 years?
I was residing in Belchertown for about 3 of those years, and then I moved back to Springfield. So I've been in Springfield for about 3 years as well.
And so you've had stable housing?
Yes, sir, I have.
Okay, so I thought I heard you say that somehow the DCF had failed you because they didn't assist you in housing stability.
I do not have affordable housing that would be suitable for my children. I currently rent a room and I receive disabilities. So with my financial constraints due to my disabilities, I'm not able to afford a full rent along with the household utilities.
And so right now you're in a position where you wouldn't be able to have your child live with you? Is that what I understand you to say?
Correct, Your Honor.
Okay. What else would you like to share with us?
The history is pertinent, Your Honor. I aged out homeless with nowhere to go at 17 years old, and it's been a constant struggle throughout my adult life. And I've even requested voluntary services through the Department of Children and Families in 2006 prior to things escalating because I was in an unhealthy living situation, and they rejected me and they said, no, we're not a housing agency. So the housing has been very prominent, and it goes hand in hand directly with the codependency that's been an issue in my life. I've been able to resolve the aspects in regards to codependency being an addiction. However, that was not anything that DCF ever mentioned until 2021 when they removed my son. And it's been an underlying issue throughout the entirety of the case because my parent-child bond was also severed with my mother as a child, and I was aged out with zero supports in place, and I do struggle with nonverbal learning disorder as well, so I never had any mental health
Did
services.
DCF, excuse me, did DCF at some point, though, try to work with you to get you into therapy, counseling related to partner violence and anger management? Did they do those things at all?
I did those things myself, Your Honor. I already had those services in place. I understand the importance of treating my mental health.
At some point, did DCF have an action plan that you agreed to?
The last action plan that I saw was in 2017.
So that's a yes. At some point, they had an action plan, right?
At some point, there was another action plan for the removal of Henry that I never received copies of after asking repeatedly. So there was an extra one that they added housing and employment on there, although they know that I am disabled and housing has been my #1 struggle.
Okay. And at some point, as an adult, did your mom have to get a restraining order out against you?
I went to court and objected that restraining order, and it was removed right away. My mother was coerced by DCF, and I was able to prove that to the judge at the time. So that was immediately dismissed right away.
But at some point, your mom got a restraining order against you. Is that right? Before you
She
got
did.
it, before you got it undone or dismissed or whatever it is.
Correct.
Okay. And when you had your action plan, what were some of the things that were on it?
I don't remember. I don't have a copy. I never received copies of it. Part of my disability and part of the court-ordered reasonable accommodations is that they were supposed to provide me with written copies as well as emails, and it has to do with my ability to retain information as a result of my nonverbal learning disorder.
Okay. And so the child is now 9 years old, is that right?
She will be 11 on the 16th.
11. And the last time she lived with you was when she was 2? Is that right?
2017, we were reunified shortly.
Well, that was for a week. Is that correct?
Correct.
All right, so before that and then after that, other than that week, she hasn't lived with you in the last 9 years. Is that right?
Correct.
Okay.
They were actually reunified into unstable housing with me as well, twice.
What's that?
My children were reunified back with me on 2 separate occasions when the underlying issue of the housing and codependency still had not been addressed. I wasn't ready for the first 2 reunifications, and I didn't have the pertinent information to be able to break the cycle of codependency in my life. I didn't even know what it was. I never heard any mention of codependency until 2021, and it's very frustrating because when the parent-child bond is severed, that essentially creates a cycle of codependency. And my mother's parent-child bond was severed as well. This goes back 3 generations in my family of DCF involvement and no reasonable efforts to help the mothers become financially stable on their own, which forces us into a cycle of codependency in order to meet our own fundamental needs. And that's been my underlying struggle. I watched my mother go through it as well. So my #1 concern with DCF has always been that I need affordable housing. Had I been in affordable housing, or had I been afforded the independent living program when I aged out, or the FUP program upon those 2 prior reunifications, I'm very confident that my children would still be with me to this day, Your Honor.
Is there any relationship or connection at all between your housing situation and the numerous incidents of partner violence or domestic violence in the home?
It's a direct result because
How so?
I was relying on these individuals for shelter and assistance with food and meeting my basic needs. I'm sure you guys are aware of Maslow's hierarchy of needs. You know, as long as my housing is not stable, I won't be able to thrive. And especially considering the fact that I do have a nonverbal learning disorder, I do require reasonable accommodations and extra support. But the DCF supervisor did testify under oath that I'm one of the best mothers the department has ever worked with. And it's not the parenting that concerns them, it's my choice in partners. Now I've been single for the last 4 years, working on healing from the codependency, gaining insight towards the link between the codependency and the domestic violence in my life. And it's just very disheartening that not only could this have been prevented, and it should have, but the department had numerous opportunities to educate me on the topic of codependency and bring the cycle to an end. And instead, I feel as though they're perpetuating not only the cycle of codependency by severing the parent-child bonds, and they're also causing additional trauma. They're exacerbating the issues. Right now, oh, excuse me, I know I wasn't supposed to say her name. Excuse me. No, my child right now is so comfortable where she's been, and she doesn't realize the long-term effects of the severing of the parent-child bond.
Sure.
She won't go, you know, I'm just very afraid that the children will fall into the same cycle because DCF is continuing with the same actions that they've portrayed with my mother and myself.
And right now, the child lives with your mom, is that right? In fact, two
Yes, she does.
of your children presently live with your mom, is that right?
Yes, sir.
Okay. And when was the last time you saw your child?
I'm only allowed to have 4 parent-child visits per year right now with her. My last visit was, I want to say, right before Christmas. And the last time I attempted to schedule a visit, DCF informed me that the child requested not to do in-person visits and wanted to do Zoom visits instead. So at that point,
do you schedule your visits through the department, or do you just schedule them directly with your mom?
I used to schedule them with my mother. Things were going great at that time. Now I have to schedule them through DCF, and there's just been the miscommunication. I never know who to get in contact with. The workers change all the time. I do have a direct email for the supervisor, but the last conversation we had was her telling me doesn't want to see me, essentially.
So I see you have a couple minutes left. What else would you like to tell us?
Just the importance of providing the reasonable accommodations that the judge ordered them to provide. That was, you know, not only did they disobey the direct orders of the judge, but they made things extremely more challenging for me to be able to reunify with my children, as well as the reasonable efforts in regards to housing. I think since I aged out at 17 with no support, it was an obvious, foreseeable pattern that I was going to follow into the same footsteps that my mother did. And at this point...
May I ask you a question? You said a moment ago that DCF had disobeyed direct orders of the judge. Could you just tell us where in the record we'll find the evidence of that?
In the last trial that took place, the court directly ordered the department to provide reasonable accommodations in regards to my nonverbal learning disorder, as it was a new diagnosis at that time.
And do you remember what day that trial was, what day that order was issued, and did you raise to the judge that you didn't think DCF was complying?
That's part of my disability, is unless I'm actually looking at the dates and times, I do have a hard time remembering exact dates. I do know it was during the trial, and I do know that I had addressed it with the DCF workers several times. However, the DCF workers continued to change. So I had to keep repeating my concerns over and over to different people, and I requested copies of the service plan numerous times as well, which is a huge factor, because how am I supposed to know whether I'm being compliant or not, or which services I'm supposed to be engaged with if I don't have my service plan? They continued to have me take parenting class, anger management class, and domestic violence courses, which I did take those classes 3 times. I did gain some good insight. However, the underlying cause has always been the codependency. The domestic violence is a surface issue. DCF is legally obligated to treat the underlying causes of the.
Sure, I understand. Let me interrupt you one more time. I have one other question for you, and then I see that's your time. Did you participate in the trial?
I was
The
there.
most recent trial? Were you there for the
I
trial?
was there. My most recent trial would actually have been with my son, and I was not
With respect
there.
to this trial, with respect to this
With
child.
this trial, yes, sir, I was present. And at that time, I did have good, effective counsel. I had a great attorney. She unfortunately got sick and had to remove herself. That's when the 2 reunifications took place, when I
understand,
had that
but you were
attorney.
present. But you were present at the trial. Is that correct?
Correct.
Okay. I think we're going to have to leave it there. We'll now hear from the department, who's splitting their time along with child's counsel. And so who's going to go first, Mr. Bayless?
Yes. May it please the court, Jeremy Bayless for the Department of Children and Families. We're here today on an appeal from review and redetermination proceedings, proceedings in which mother was present virtually for a portion of one day, and then after 3 consecutive orders that she appear in person for the subsequent dates, and she did not appear, the court drew a negative inference and the trial concluded. This is a mother who in 2018 was found unfit after a full trial to parent this child. Those findings are included in the record.
Sure, we've had a chance to look at them. She says that many of her concerns and her issues and her challenges lie at the foot of the department, because they failed to give her the adequate services and failed to properly assist her in becoming a better parent through this generational interaction that her family has had with DCF. What do you say about that?
Certainly. So I guess there's the procedural issues is that these are being raised for the first time on appeal, but substantively, getting into them, there is, I think, some confusion as to what the department's role in reasonable efforts is. The department, social workers are not psychiatrists, they're not psychologists, they cannot diagnose, they cannot treat. What the department does is it creates the action plans and makes referrals to services to assist with the identified parental deficiencies. And mother's parental deficiencies were the ongoing violence, the mental health concerns, and so she was referred to, and she started but failed to complete therapy, dialectic behavioral therapy, anger management. The department was working with mother. Mother eventually reached a point where she was no longer cooperative or no longer engaging and withdrew from services. This has also affected her housing. The department referred her to its housing specialist. The department does not provide housing. We don't have apartments that are available or anything along those lines. But the problem with mother's housing is that in addition to the constraints with her income and her disability, is that mother was being terminated from housing programs and evicted for failing to follow the program rules. That happened in 2017, and it happened again in 2021. There was the period where she was living with a client in Belchertown. She moved out into a shelter, and then I believe it's in the Exhibit Appendix 1 on 418 is a cite to a court report, but it's in several of the court reports that mother was then terminated from that shelter and had to move back in with the client. So mother's housing instability is both occurring because she's not benefiting from her abbreviated participation in therapy and anger management, but it's also because she's creating this record of evictions that then make it harder for her to access public housing resources. And the department did attempt to work with her for that, and it's noted repeatedly in this record that the real impediment there was that she wouldn't or could not maintain employment, and that she had that history of evictions that was banning her, or not banning her, making it more difficult to get housing locations. With regards to the sort of generational piece that she's discussing, in terms of its impact on this decision, we're looking at the department's reasonable efforts to eliminate the need for removal or promote reunification, eliminate the need for removal, and so on. So even were there a failing with the grandmother, that is something that should be considered in evaluating what we're doing, but we can't very well go back and undo that at the start of the proceedings.
Sure. Was reunification the goal at one point?
Yeah, reunification was attempted. There was a 1-week failed reunification in 2017.
And what happened then?
I believe mother was unstable. I don't know, but personally, I mean, her living situation was unstable. During that period, one of the children appears to have at least subsequently alleged that he was sexually abused by one of mother's partners. And then mother sort of took no action after learning that, and that was part of what was considered in the 2018 trial. And then after the 2018 trial, we basically have mother persisting in the same or worsening conditions. So after 2018, mother has been the subject of 4 different restraining orders. She's had at least 7 police responses to domestic violence or conflict incidents. These are not incidents where she's, at least not all of them are incidents where she is a victim. They're instances where also she is instigating conflict, she's instigating violence. And so what we see at the time of the trial, even putting aside the fact that she didn't attend and she didn't participate and she did not follow the court's orders to appear in person, is that there had been no improvement. And after the 5 years following her unfitness finding and the, roughly 7 years that this child had been in care, as we know from Nancy and countless other cases, the child has a need for permanency to break that generational cycle of children aging out and not having the outcomes that we want. This child has a right to stay and know that her current living situation, where she is happy, where the evidence reflects that she is doing well, where she is exhibiting anxiety at the prospect of leaving that placement and returning to mother, she has the right to know that that is her permanent home, and the court correctly found that the termination of mother's parental rights was in her best interest to ensure that she has that right and she has those supports.
The mother, during her argument, referred to the court having ordered DCF to provide certain accommodations and DCF having disobeyed that order. Can you point us to what she might be referring to in the record?
I admit I am unclear as to what that's referring to, but the best I can do is say that this was it's not raised and it's not preserved, and part of the reason for that is not just sort of the technical procedural barrier, it's also that if there was a case where the court had ordered any specific services, as she says, to address codependency or her learning disability or any of the other barriers, the reason those need to be raised meaningfully is so that the department or a judge who is trying to evaluate if the department is in fact violating the court order has the ability to look at, with an evidentiary hearing, what the department is doing, is the department providing service plans, is that accurate?
So when you say raised, you mean she needs to make that argument to the judge, hey, Judge,
yes.
DCF
Yes.
isn't obeying your order, so that the judge can hear from you and then make a determination about whether DCF is obeying or not.
Yes, Your Honor. Thank you for making that a
Are
little
you
bit clearer.
suggesting this is the first time that you've heard that claim today here?
Yes. It's not in either of the briefs. It certainly is the contention that the department did not, in Mother's supplemental brief, the department did not adequately work on her codependency, but that was not raised as a failing in the department's efforts at the trial level And also that is something that is in fact directly linked to the services mother had included in her action plan. There's no.
Sorry?
I'm sorry, that is sort of this sort of topic, an issue that would have been directly linked to the therapy and to the dialectical behavioral therapy. The stuff that mother was included on her action plan that she did start but did not complete. That's an instance where, to the extent that that is an issue that persisted.
So was that her primary problem, that she would engage in the services, but she didn't follow through with them?
With regards to the anger management and the mental health piece, yes. That she did, in fact, have the ability to participate in services that would have addressed that issue, and then she terminated them. Regular therapy, dialectic behavioral therapy, anger management. But then we also need to look beyond, because just having a disability is obviously not enough. It needs to manifest in a way that puts the children at risk, and this record shows that that was still the case. Mother was still regularly engaging in partner violence and violence around the home.
Those, as I understand it, continued really unabated until trial?
Yes. Including an instance where at one of the visits she grabbed onto the child and held her without letting go while screaming. You know, the things that have an impact on this child, which is why the possibility of a return home would have put her at great risk and made it not an error for the court to determine that termination was in her was in her best interest. And if there's no further questions, I see my time is lapsing. Thank you, Your Honors.
Thank you, Attorney Bailiff. Attorney Durant.
Good morning. May I please the court? Colleen Durant on behalf of the appellee child. This case has been pending for 7 long years, from the time of removal in April 2016 until the decision was rendered on August 2023 as termination of mother's parental rights. It's been 7 long years that my client has not had permanency. And I am asking—
move that mic toward you just a little bit. Can you move that mic toward you?
Toward me.
There you go. Thanks.
Thank you. And I am asking the court today to affirm the decision of the lower juvenile court in the termination of mother's parental rights. Justice Desmond, you asked a question about mother's stability at her house. Just to address that one, the time of removal was April 2016, and that was due to 3 51As that were filed at that time. 2 of the 51As involved mother's boyfriend being at the home in front of the children selling heroin. The second 51A, which was significant, was a domestic altercation between mother and her boyfriend, where the boyfriend punched her in the face and she fell to the floor. There was a third 51A as to that same complex, where mother engaged in community violence. She got in a fight with a neighbor, and child was injured during that situation. Her leg was broken. It happened in the living room of the house. Her leg was broken, and mother didn't seek medical attention for 2 days. So that issue there, that type of conduct is what my colleague was talking about. Mother's had many opportunities. If we just talk about the services, she's had many opportunities for the housing. 2017, she was in a YMCA shelter. She couldn't follow the rules of the shelter. She was getting in a fight with the other women of the shelter. She was letting her boyfriend over. She couldn't follow curfew.
So what were some of the things that were specifically on her action plan?
Yes, Your Honor. The items in her action plan, and they didn't change from 2016 to the first hearing on the merits in 2018, and they existed in 2023 at the time of trial, the 7 years, addressing her mental health, domestic violence education and counseling, anger management classes, addressing her homelessness, and addressing her unemployment. And also taking care of her legal matters, because mother had open warrants. And all of these services were extremely necessary to be able to provide my client with a safe, stable, and home life. As to just the mental health, we discussed that. But mental health, mother was to engage in therapy, psychiatric services, take medication. And her mental health, as recent as the trial year, 2023, the juvenile judge was very accommodating because we had 6 dates scheduled for the trial. Many of them had to be moved because mother asked them to be moved, and mother was given the opportunity to appear virtually. The only date she attended was May 11, May 11, 2023, she was extremely disruptive to the court. She came to court, she was videotaping from a porch somewhere, and she was videotaping the judge in the proceedings, asked numerous times not to record. She continued to do that.
Is this also the first time for you hearing about the department's alleged failure to follow a court order that they accommodate?
Yes. Your Honor, I believe what it was to work with a housing specialist, but because of the history of housing, again, it was very difficult for the housing specialist that I saw in the dictation because of all the past evictions and because of her conduct. And again, just briefly, 2017, she was in a YMC shelter. 2018, she was dismissed from that shelter because she couldn't follow the rules. 2019, she lived in 5 different locations that year with friends. She was asked to leave. 2021, she was able to live in a shelter in Palma. Again, the same issues arose. Not following the rules of the shelter, having her boyfriend over, her conduct. 2022, she stayed with a friend. In May 2011, at the time of the trial, 2023, she informed the judge she was again homeless. But even though homeless is not a reason for someone not to parent a child, you have to look at the whole entire issue. It's mother's conduct and her actions and her domestic violence. And the other, as we went through the topics on her service action plan, 2 significant ones for mother were her domestic violence classes and education. Mother acknowledged to the department early on, right after the 2018 hearing, that she did have difficulty in her relationships with her partners. But she didn't change. She took the classes, she started to take the classes, but she never could put that in to show observable changes. December 2018, mother was found to be the aggressor with one of her past boyfriends. 2019, boyfriend MK. Mother was involved in another domestic violence.
I'm just going to interrupt you a bit because we've read that. That's all in the
Yes.
record and in the brief. I'm just going to ask you to just comment briefly on mom's bond with child.
It was definitely a bond. Mother did say today, even though it's out of the record, that she's seen the child in a recent amount of time. Mother has not seen the child in over a year. At the time of trial, and from what I read, there was a bond between the two, and I think the judge was very accommodating in giving, in the 2018 and at the end of 2023, visits with mother. My understanding was she's not always able to keep those visits, and the latest that I was learned when I met with my client recently was that there hasn't been communication in about a year.
I think we'll leave it there. Thank you. Thank you all. The matter stands submitted.
Thank you.
Do you have any more questions? Sorry about that. Do you have any more questions?
No.
Sorry about that.
No, it's okay.